We've got about a minute till class. I try not to waste lecture time on housekeeping things, but the powers that be tell me there's some names missing from the seating chart. Who knew? So I'll pass this around again. If your name's already on it, so be it. Just pass it to the next person. If your name's not on it, then go ahead and write your name on it. Then I can hand it back to the powers that be, and hopefully they'll be happy with me. Sound good? I'll start with you. Also, by the way, if I've updated the website. You can find there the link to the graded essay and the information about that. So I hope that comes in handy. In production, but not yet released, and I mean that literally, because I probably was working on the slides for it this afternoon. Here's the video I'll record for you when I explain the questions that you asked and answered of midterm, why the right answer was the right answer. So thanks for housekeeping for you. Sorry to waste a minute of your time. Oh, maybe I didn't finish that housekeeping. I've also got lead counsel Bank. I've got Heath, Sarah, and Rochelle. Heath, Sarah, and Rochelle, are y'all here yet? Looking for Heath, looking for Sarah, looking for Rochelle. When you see Heath, Sarah, and Rochelle, thank them for the excellent outline that's available on the website. They did a great job, and I think they deserve a round of applause. Yes, thank them for that. Also, we've got two lead counsel who wish to be heard. Here I am, it is I, says lead counsel. One is Tanya, the other is Josh. Tanya and Josh, are you here yet? Josh is here. All right. Tanya? Tanya's here. All right. And last but not least, Caitlin from last week. I never called upon you, Caitlin.
I made sure to speak up last
week.
You
did speak up. So thank you. I liked your comments. Do you feel bad that I didn't call on you directly?
I'm okay.
You're okay with that?
Sure, I spoke up and I'm like, whatever, I was there, I participated.
You did. You were here, you participated, no doubt. You've got full credit. I'm just hoping you weren't offended by the fact that I could have called upon you more but didn't.
No, I appreciate that last week was like one of those, you had to go as fast as possible.
Yes, it was oversight on my part. I thought everyone had participated in the outlining part. I missed the fact that you were choosing to be a speaker, so I apologize for that.
No problem.
Yes.
We are good.
Yeah, you did great. You did great. And I'm glad you're not miserable about it. If you were miserable about it, I had a story ready for you because misery loves company, right? So last semester, that mini semester y'all have around here, what do you call it, PRI or something like that? I spent about a year creating my own class, and I put my heart and soul into it. One of my favorite topics, professional responsibility, is focused on the MPRE. So I put on the class, I gave it my best. I was hoping it did well. I couldn't wait to see the student reviews, as to what they thought of it. I very shyly asked the dean, did you have any of those student reviews back yet? And she said to me, well, I didn't do any student reviews for that PRI semester. So I quickly responded, well, that means you didn't get a single negative comment about my class. Yeah. But hey, thank you. I was fishing for that compliment and I got it. Thank you so much. Thank you so much. Thank you. I shamelessly fished for that one. BJ, thank you kindly. Thank you very much. Yeah. But today's lecture, and I'm looking for a new video monitor. As you know, I don't know who among you failed to pay your tuition, but our monitors have been dying one by one. Have you noticed this? Yeah, stage right, your left. That one was dead for weeks. Stage left, your right. Slowly but surely faded into oblivion. And now, if you've noticed, the big screen is a little dull, So I'm going to try to stand next to this one, or maybe I'll go back to the big screen. What works best for y'all? I don't know. Yeah, that's about as much interest as you've got. I understand. All right. So with that said, let's get this party started, shall we? Go away, creditors. That's my homestead, says the Floridian. And the Floridian can say that because a Floridian has homestead rights unlike any other resident of any other state in this great nation of ours. Florida's homestead law has been described by the courts as unique among the homestead laws of our nation, and I dare say that that's probably a fair assessment. We are going to look at the literally unlimited protection, unlimited financial protection that Florida's homestead law provides to the homesteader here in Florida. And we're going to see if there is some sort of limit to that. We're going to look at where that came from, look at the basis of that law, and try to determine how we, as attorneys, can make best use of this law on behalf of our clients. But before we do that, we have one pithy chapter to cover. We will cover homestead for most but not all of this class. We will cover homestead for most but not all of our next class. But before this class starts with homestead, we have one pithy chapter to cover, and that has to do with elections. Has election law been in the news at all lately? Boy, what a loaded question that is, right? When I wrote your case book just 2 years ago, I made reference to the election law case of Bush V Gore from the Supreme Court of the United States that went back to the year 2000. Little did I know at that point that that would be ancient history and not on the top of your minds when I lectured to you about Florida's election laws just 2 years later. But certainly that's a topic that's on our minds. I'd be remiss, despite the pithy nature of that chapter, to not cover it, and so I will. And before I cover it, I would be remiss, in my opinion, not to start this class as I've started every class, to start this class with a prayer. As always, I'm not praying at you, I'm praying for you. I'm praying for your success here in law school and in your legal career. And since our topic is election law, I think I should also be praying for our great nation. To the extent that our election laws may be less than perfect, let us pray for a more perfect system, shall we? And with that in mind, I put the book down for just a moment. And as always, I pray in the name of the Father, and of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Amen. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. In the name of the Father, of the Son, and the Holy Spirit. Amen. So our first topic before we get to homestead, and I know I hear you, McGinley, I want more homestead. McGinley, I gotta have more homestead. Give me my homestead. I will. But as you wait on bated breath, I first cover elections. Elections. Article 6 of Florida's Constitution talks about suffrage and elections. And of course, so does the very well-written outline that we've got from our lead counsel today that's available for download for you at our website, flaconstitution.com. Just click the link like you always do. Well done, well done. Section 1 of Article 6 of Florida's Constitution talks about regulation of elections as follows, and I quote, "All elections by the people shall be direct and secret vote. General elections shall be determined by a plurality of the votes cast. Registration and elections shall, and political party functions may, be regulated by law. However, the requirements for a candidate with no party affiliation or for a candidate of a minor party for placement of the candidate's name on the ballot shall be no greater than the requirements for a candidate of the party having the largest number of registered voters." Obviously, this type of phrase that I just quoted to you from the Constitution is in need of enabling statutes. And indeed, Florida has many enabling statutes, many of which were edited or amended in our most recent legislative session. So if you're a practitioner and you're engaged in election law, you are on the cutting edge because you have to know what's been proposed and what has passed and keep yourself up to date. I ask in the text, is the election process of any state more infamous than Florida's? And that's when I cite to the case I mentioned a moment ago, that SCOTUS decision from the year 2000 called Bush v. Gore. Is there anyone who didn't cover Bush v. Gore in their Common Law 1 class? Everybody covered it. So you all know what I'm talking about when I reference the hanging chads, right? That was us. That was Florida. That was our butterfly ballot. That was our hanging chad problem. That's where a dimple might or might not reflect the intent of the voter, depending on which canvassing board was looking at the ballot during the recount or not the recount. Should we recount? Should we not? Should we recount all counties? Should we recount just some? You remember Bush v. Gore. And you remember the aftermath may have been some distrust of the election process. Here in our republic democracy, we need to have the people to have faith and trust in our democratic processes. These processes have to be trustworthy. So Bush v. Gore might have been the canary in the coal mine. It might have been the harbinger of things to come. It might have been a warning to us as to what we've seen in the past 18 months or so. But regardless of your perspective of those past 18 months, you have to wonder whether Florida has done enough to safeguard the election process. And that's why I included in this pithy chapter the case of Orange County versus Singh. This was not a case from the Supreme Court of the United States. This was a case from the Supreme Court of Florida. It was from 2019. And it involved the county we're standing here right now, Orange County. This involved the Orange County Board of County Commissioners enacting an ordinance proposing an amendment to the Orange County Charter to provide for term limits in nonpartisan elections for 6 county officials. And the outcome of this case depended upon whether or not they had the right to do that. Let's turn to our lead counsel, shall we? And see what they think about whether or not they had the right to do that.
Yeah.
You good with this one, Josh?
Yeah.
All right. I hate putting people on the spot. Maybe that's wrong. I guess if I'm going to step into this law professor profession, at least on Wednesday nights, I should be loving putting people on the spot, but it's not my thing. It's not my thing. All right, Josh, if you're up for this, go for it, man.
Yeah.
What's happening in this case?
So the court says, well, actually, I'll go back. The county passed a referendum in 2014 saying that all elections in the county would be nonpartisan for county seats or clerks and whatnot. And also the term limit. And essentially the court said that.
Now, what's wrong with that? So nonpartisan, partisan, term limit, non-term limit, what's the issue?
The issue is that the legislature of Florida passed an election law.
Aha.
Yes, that sets out.
Well, let me interrupt you there, since I keep interrupting you anyway. I apologize this time. But is that something that Florida's Constitution allows? Can both Florida's legislature and a lesser sovereign, such as a county, both pass laws on the exact same topic? Is that allowed under Florida's Constitution?
The court said no, because one, it was expressly preempted in the statute, and two, it was a conflict of laws. If it wasn't expressly preempted, it'd be a conflict of laws in the legislature.
I like your answer, but let me break it down. It's a correct answer, but I'll break it down. First, to break it down, yes, the legislature and a lesser sovereign, such as the county or a city, can pass laws on the exact same topic. Florida's Constitution allows for this. However, Florida's Constitution also recognizes preemption, just as you mentioned, Josh. And this was the crux of the holding of the case. Give it to us again. Was there preemption?
Yes.
There was preemption. Why so?
Well, one, it was expressly said in the statute that it was preempted.
Aha! So the court did something that not every judge does, but we wish they would. The judge opened the statute, read the words, and interpreted those words to mean exactly what they say. That's a beautiful thing when a judge does that. Don't you agree? That's a beautiful thing. So the judge did that, and what did the words say?
The exact wording, I believe it was that they were expressly preempted from.
Expressly preempted. So was there any question as to whether the intent of Florida's legislature was to preempt local law? No. For an honest reader of the statute, no. Why? Because the statute said plainly, on its face, in the language of the statute, as written and passed by Florida's legislature, that its intent was to preempt. Am I doing good so far, Josh?
Yeah,
And you're doing great too. Go on, man. I keep interrupting.
and then the court went on to say, even if there wasn't expressive preemption, there was a conflict of laws with the way the county was doing a non-partisan election and the way the statute reads, allowing a partisan election. They said that was a conflict of laws.
So the court ruled with a primary ruling that there was express preemption, but it also had an alternative ruling. If you've been a litigator and you've gotten an order like this, it's kind of like a double whammy, right? You're reading the order and the judge is ruling against you and you're thinking to yourself, I might have grounds for appeal here. You're thinking to yourself, I think the judge might have erred here and an appellate court might agree. And then all of a sudden the judge says, but even if I'm wrong, I would have reached the same result for this other reason. And you, the litigator, says, no, that doesn't help my potential appeal. Josh, what was the other reason? Oh, you told me. Yeah, I'm making you repeat yourself.
Okay, the conflict of
Yeah, even if it wasn't express preemption, they saw a conflict of the law, and the resolution was to defer to the legislature, not to the Board of County Commissioners. Yeah. All right. Well done. Thank you for that summary. That brings us to our notes and questions to consider. We are on page. How did I lose the page so easily? Okay, case starts on 313. Case rambles on 317, 319, 321, 323, 3. I don't see any notes and questions to consider. All right, so we didn't get any of those wrong, did we? Okay. It's times like these I wish I could blame the slides on someone else. I'm to blame. All right, so now just a few other things to cover when it comes to election law. Then we'll take our break. I know it's early, but I'd rather break in between topics, election law and homestead, than to simply jump right into homestead and take a break in the middle of homestead and then come back to homestead. It seems a little bit confusing that way. So forgive the odd placement of our break. But just a few notes to consider, even though they're not notes and questions to consider. Up here on page 324, when we talk about subsection B, electors and disqualification. And that's almost like a vocabulary list, is it not? But if we're going to be lawyers, we're going to have to know the jargon of our profession. In election law, an elector is someone who is eligible to vote in an election. So when we speak of an elector, we're talking about an eligible voter. A disqualification is something that makes someone ineligible to be an elector. So if you don't have the status of elector, one reason might be due to a disqualification. That brings us to Article 6. We've already looked at Section 1. Here on page 325, we look at Sections 2, 3, and 4. Section 2 gives us who is eligible to be an elector under Florida's Constitution. Every citizen of the United States who is at least 18 years of age and who is a permanent resident of the state, if registered as provided by law, shall be an elector of the county where registered. So what are some of the requirements under Florida's Constitution? First is citizenship in the United States, correct? 18 years of age or older, correct? Permanent resident of the state, correct? And went through the hoops, jumped through the requirements, submitted the paperwork, and got themselves on the rolls to be registered as provided by law. Subsection 3 talks about an oath, and every elector takes this oath, quote, I do solemnly swear or affirm that I will protect and defend the Constitution of the United States and the Constitution of the state of Florida, and that I am qualified to register as an elector under the Constitution and laws of the state of Florida, end quote. So it could be the crime of perjury to have taken this oath when one was not eligible to do so. Subsection 4 talks about those disqualifications. It tells us here a person convicted of a felony before the restoration of civil rights is ineligible, but of course there are enabling statutes that spell that out in greater detail. Subsection B, again, talks about certain types of felonies. Subsection C says no person may appear on the ballot for re-election to any of the following offices if by the end of the current term of office, the person will have served in that office for 8 consecutive years. And that is important to talk about because that part of Florida's Constitution, in part, was found to be unconstitutional under the United States Constitution. I draw your attention to page 326, where there really are notes and questions to consider. Maybe that's what my slide was talking about. Sure, yeah, that's where I was going. Okay, so on page 326, notes and questions to consider. Note 1. Note that the language in Florida's Constitution, Article 6, Section 4, talks about term limits. That section violates the U.S. Constitution as applied to candidates for the U.S. Congress. Why is that? Because SCOTUS tells us so. In U.S. Term Limits, Inc. versus Thornton, a 1995 decision of the Supreme Court of the United States, SCOTUS considered a similar term limit appearing in the Arkansas state constitution. The court affirmed the Arkansas Supreme Court's ruling that the term limits imposed upon candidates for the United States Congress was a violation of the U.S. Constitution. Specifically, SCOTUS held that states cannot impose qualifications upon candidates for the United States Senate or the United States House of Representatives that are in addition to those imposed by the United States Constitution. The 10th Amendment to the United States Constitution did not reserve such powers to the states, according to U.S. Term Limits versus Thornton, 514 U.S. 779, U.S. Supreme Court 1995. So there again is another example of something we began talking about in our very first lecture together, in our very first class, in our very first hour of this semester, how the Constitution of the state of Florida itself can in part be unconstitutional. Here's a part that is unconstitutional. Then I draw your attention to note 2. Note that the language in Article 4, Section 4, stating, quote, any disqualification from voting arising from a felony conviction shall terminate and voting rights shall be restored upon completion of all terms of sentence, including parole or probation, quote, and the language surrounding it were the result of Amendment 4 that passed in 2018. So with those notes considered, and with you dying to talk about Homestead, is there anyone that wants to belabor this topic before we take our break that leads us to our Homestead discussion? Any questions? Any discussion? Any comments? Going once? Going twice? Let's take a 10-minute break. I'll see you back in 10 minutes, and that's when we'll talk about your favorite topic and mine, Florida's homestead laws. See you in 10. Hey, how goes it?
Yeah,
That was funny, right?
without it there.
Yeah.
Now
Okay. Yeah. Sorry about that.
I was talking about one. I didn't know that you were the founder. Yes, I will.
Yeah, we've done like so the idea is just to get out of the office. But yeah, we actually have quite a bit now. They have
I'm trying to do this.
You know what's crazy is that when my mom had they told her in the hospital to leave the house. They were like, never talk, never walk, never function. And my mom was like, you don't know who I am. You know, whatever, 35%, that's what happened. But so for the first 2 years of his life, he had all kinds of issues.
Florida's homestead law, as I mentioned, is unique among the homestead laws of our nation. One thing that was unique about it from a law student's perspective is for an extraordinarily long run of many years, it always was a topic that appeared on the Florida bar exam. Of course, there's nothing in the Florida bar exam requirements that require this topic to appear, but since it appeared so many times, it's often thought of as a necessity for studying before taking the Florida bar exam. Will that be true for your Florida bar exam? Who can tell? But the common wisdom is don't neglect to study Florida homestead before you take the Florida bar exam. Another common wisdom is that Florida is a debtor's haven because of our homestead laws. There have been more than one example of celebrities or notable individuals who were about to face a large judgment and therefore took a large sum of money to buy themselves a very large and expensive homestead here in the state of Florida. Were they wise to do so? Yes, they were. Is there a financial cap as to how much value in your home is protected if you qualify for Florida's homestead? No, there is not. So perhaps you're living in the modest one-bedroom condominium that you purchased for $95,000. Or perhaps you're not living modestly. Perhaps you're living in an extravagant mansion on the ocean that you paid millions and millions of dollars for. Your millions and millions in value is just as protected as the one-bedroom $89,000 condo is. So it can be a way to shelter money of an almost unlimited amount, limited only by how much you're able to gather and buy in a home. So for that reason, every lawyer, as well as every law student, is wise to study homestead. Because even if you're not doing estate planning, and that comes up as we study homestead, even if you're not doing family law, and that comes up as we study homestead, even if you're not doing litigation, and that comes up as we're studying homestead, still, if you practice here, you might want to live here. So we're talking about your individual rights. So let's take a closer look then at homestead law. And one thing that always confuses me is what all the confusion is all about. I mean, homestead is so simple. I can sum it up in a single slide. And here it is, folks. Homestead is a city within Miami-Dade County. Its total area is 14.4 square miles. It's about 35 miles southwest of Miami, about 25 miles northwest of Key Largo. And its racetrack is the annual finale of the NASCAR Cup Series. So with that said, unless there are any questions, I guess we're done with our discussion of homestead. Nah, just kidding. Yeah, you could put that down if it comes up as the question on your bar exam. I don't know how many points you're getting there. Yeah, you might want to do more than that. But since I told that joke, I do want to point out that the homestead laws I'm about to share with you apply statewide, not just within the boundaries of the city of Homestead, okay? So that wasn't my point in putting up the slide. My point was an attempt at humor. And that describes all of my humor, right? As an attempt, right? Okay, so let's get a little more serious. Let's talk about homestead. It comes from Article 10. Let's look at subsection 4 of the Constitution of the state of Florida. There shall be exempt from forced sale under process of any court, and no judgment, decree, or execution shall be a lien thereon, except for the payment of taxes and assessments thereon, obligations contracted for the purchase, improvement, or repair thereof, or obligations contracted for house, field, or other labor performed on the realty, the following property owned by a natural person. 1, a homestead, if located outside a municipality, to the extent of 160 acres of contiguous land and improvements thereon, which shall not be reduced without the owner's consent by reason of subsequent inclusion in the municipality. Or if located within a municipality, to the extent of 1/2 acre of contiguous land, upon which the exemption shall be limited to the residence of the owner or the owner's family. But that's not all that's protected. Also protected is personal property to the value of $1,000. These exemptions shall inure to the surviving spouse or heirs of the owner. All right, McGinley, you can read. I'm impressed. But how about a little explanation? Well, let's break it down bit by bit. First, Florida Realty is a homestead. 1, when it is owned by a natural person. 2, who intends it to be his or her permanent residence. 3, and who is a legal owner of the real property. 4, that meets the size and contiguity requirements of the Florida Constitution as I just read them to you. Let's look at that first requirement, owned by a natural person. How strictly is this construed? Obviously, if we are an individual and we own the property individually and we are flesh and blood and we have not passed on, then we are a natural person. But what if we enjoy the sacrament of marriage? What if 2 have become one flesh? Yes, even in a marriage, if the property is owned, joint tenancy by the entirety, or stated somewhat differently, owned as husband and wife, you still have met the natural person requirement. What if the individual, or even the husband and wife, or the husband and husband, or the wife and wife, have done some estate planning and created a trust? Perhaps you've done this yourself. In order for a trust to be valid here in the state of Florida, if done for estate planning purposes, that trust has to be funded before death. One of the ways estate planners often fund the trust is to draft a deed, deeding the property into the trust. This is a favored way of funding a trust because it is readily ascertainable after death that the trust has been funded. Most deeds are filed with the county, and the county records will reflect that the trust owns the real property, and therefore there should be no dispute that the trust was funded on a particular date, a date which was before death. But now, who is the legal owner? It's no longer a flesh and blood human being, right? That's the whole point of an estate plan that involves a trust. Unlike you and I, who are flesh and blood and will go on to our maker, when we make a trust, it lives on after us because it is a legal fiction of a person instead of a flesh and blood person. So for those individuals or those spouses who have deeded their property into the trust, do they satisfy the definition of natural person? Yes. Is a trust a natural person? No, I'm not saying that it is. But for the purpose of homestead law, deeding one's real property, that is one's homestead, into the trust, but yet doing nothing else, keeping it as your homestead, means that the property is still owned by a natural person. Is that counterintuitive? Well, if so, ladies and gentlemen, hold on to your seats because I've just begun. Number 2, who intends it to be his or her permanent residence. And indeed, the Florida statutes do have a statutory definition of permanent resident, which I've included there in your text. I'm citing there to section 196.012 of the Florida statutes. You can find that on page 331 or Google it. What does it mean for someone to intend something to be their permanent residence, especially in a state like ours, where one of our state's governors was once quoted as describing Florida as heaven's waiting room? Yes, allegedly, many people come here right before they die. This is a hot spot for retirees, is it not? Some of us die peacefully in our sleep and painlessly at the ripe old age of elderly. But that's not true for all of us. You can't drive very far down a Florida street without seeing a nursing home or a residential living facility for the elderly. Some folks intend to retire there, other folks do not. The question is, if that happens to your client is in the nursing home and dies there, was the nursing home your client's permanent residence? Or stated somewhat differently, did your client lose homestead protection because your client ended up in the nursing home? It says right there, it's got to be permanent residence. Nobody intends permanently to be in the nursing home, right? So the answer is the home is the permanent residence. What? Forgive me, that's counterintuitive. I said you're supposed to be holding on your seat right now. Yeah, it's been interpreted this way. If the deceased, no matter how unrealistic their expectation was, intended to go home, then the home remained a homestead. Perhaps the deceased is in a persistent vegetative state. Perhaps the deceased has been hospitalized for months. Perhaps there is no reasonable expectation because of medical needs that the deceased would ever return to the home. If after death there is an heir willing to sign an affidavit stating that subjectively the deceased intended to return home, then homestead persists. Number 3, a legal owner of the real property. Wow, we took that property class in our first semester of law school, did we not? What was that crazy analogy? A property is a bundle of sticks. No matter how small, which one of the sticks do you own? Okay, so I got to be the legal owner of the real property. Which sticks do I have to own? What if I'm just a co-owner? Can it be my homestead? Yep. It can be your homestead. What if it's a condominium? I literally don't own the outside of the walls. I don't own the common areas. I don't own the land. It's a condominium. Can it be my homestead? Yep. Yes, it can. What if I have a life estate? After death, I have no right to pass this on. Can this be my homestead? Yep. That's an ownership interest. We're going to do an exhaustive discussion after we cover Snyder versus Davis of what Joe Percopo, P-E-R-C-O-P-O, sorry I mispronounced your name, Joe, what Joe Percopo describes to us as various types of co-ownership. And we're going to see what level of homestead protection is granted. Until we get to that greater detail, suffice it for now to state that nearly any type of ownership interest will get you at least some kind of homestead protection. And since you're holding on to your seats already, you won't be surprised to learn that even some scant means of ownership get you full homestead protection. More details to come. Number 4, size and contiguity requirements of the Florida Constitution. You saw that if it was in a municipality, you were limited to 1/2 acre. What if you had many more acres, but still within the size and contiguity requirements of the Florida Constitution, and your land now became part of a municipality? We talked about municipal law. We talked about incorporation. We talked about how a county can incorporate, the residents of the county can incorporate themselves into a city. What if they do that? Now, do I lose some homestead protection for some of my land because it's greater than a half acre? Answer is no. You were holding on to your seat, so you knew that was going to be the answer. Answer is no, you get grandfathered in if you want to use the slang. Or stated somewhat differently, you keep your homestead exemption because Article 10, Section 4 says you do. And even above points 1, 2, 3, or 4 here on the big board, I've got in quotes the word homestead. Florida Realty is a homestead. But does it have to be realty? What if you live in a mobile home or a trailer? Yes, that can be subject to homestead. As I mentioned earlier, what if I live in a condominium or townhome or fractional ownership? Yes, that can qualify for a homestead. If there is a theme to homestead, it is this: that homestead is broadly interpreted, or to give a more exact quote, because it comes from the Supreme Court of the United States, Supreme Court of the State of Florida's decision in 1997, Supreme Court of Florida's decision of Snyder versus Davis. It says this, quote, as a matter of public policy, here's the court telling me what public policy is. Let's put that aside for a minute. Quote, as a matter of public policy, the purpose of the homestead exemption is to promote the stability and welfare of the state by securing to the householder a home so that the homeowner and his or her heirs may live beyond the reach of financial misfortune and the demands of creditors who have given credit under such law. If I were to parse those words of the Supreme Court of Florida that I just quoted to you from Snyder versus Davis, maybe I could parse them this way. The motivation is to avoid homeless Floridians. The justification is that those who extend credit to Floridians do so with full knowledge of this homestead protection and therefore are entitled as creditors to no greater rights than this homestead law provides to such creditors. Is that good? Is that bad? Is that beneficial? Is that not? Those are public policy issues to be discussed and decided by the people of the state of Florida. I'm just here to tell you what the law is, not what it should be. I'll leave the should be to those with a more important role in homestead than my role. My role is to just explain it. So let me continue to do that. Florida statutes provide that a homestead jointly owned via tenancy by the entireties or via joint tenants with rights of survivorship becomes solely owned by the surviving owner upon the co-owner's death, and does so free and clear of the deceased debts and financial obligations, except taxes and liens for purchases or improvements to the property. Again, McGinley, I see you can read, but can you give me a little explanation? Sure, I can do that. All right. Two of you own the property as co-owners. And for both of you, the property is your homestead. One of the co-owners of the homestead dies. And in the will, leaves the property to the other co-owner. Maybe that's not all the deceased left behind. Maybe the deceased left behind some bills. We've all had some bills from time to time, right? It's never fun trying to keep up with the bills. What kind of bills might there be? Well, you might have power bill, right? Got to keep the lights on. Might have the food bill. Maybe you put food on the table by pulling out the Visa, MasterCard, American Express, to Discover, Diners Club. What else is out there? Credit cards is what I'm talking about. Might leave behind some credit card debt. Maybe you've even taken out a loan. Maybe you had a handyman fix the fence, and you owe the handyman or handywoman some money. You could imagine the kind of bills that someone might leave behind. With those in mind, what bills get paid? Remember, we've got two co-owners. It was homestead and his homestead for both. One has passed away, leaving the property to the other. The bills of the deceased. What about the taxes? Perhaps their taxes owed to the IRS. Perhaps their property taxes owed to the county. Regardless of the source of the taxes, they must be paid. What if there are liens for purchases or improvement to the property? Perhaps there's a mortgage. The mortgage must be paid. And we mentioned one of the bills on our potential list was the handy person, handywoman, or the handyman who fixed the fence. That's among the improvements or repairs one might make to the property. Assuming an appropriate lien exists, then that also must be paid. So these bills that I've just mentioned must be paid. These creditors cannot be denied payment merely because it's homestead. If you can't pay them from other estate assets and you, the heir, are not willing to pay them yourself, then the homestead can to satisfy those liens. But those are only certain bills. There are many others that are common. We mentioned the credit cards. What if the co-owner passes away, leaving the property to the other homesteader, who is also a co-owner, but also leaving behind a bank account with $4,000 in it, and leaving behind a credit card bill of $10,000? Do we sell the homestead to pay the deceased's credit card bill? No. Can the credit card company force the sale of the homestead in order to get its credit card bill paid? No. And under these facts, can the credit card company impose a lien upon the property? No. Under these facts, there was $4,000 in the bank account. You remember, as well as homestead protecting property, also protected personal property in the amount of $1,000. So the credit card company is not going to get the first $1,000 of the $4,000 in the bank account of the deceased, which is now the bank account of the estate because of the deceased's death. The credit card company can get $3,000 of the $4,000. But remember, the credit card company in my hypothetical was owed $10,000, not $3,000. So even when the credit card company gets $3,000 out of $4,000, the credit card company still is owed $7,000. The only other asset of the estate in my hypothetical is the homestead. But the credit card company can neither force the sale of the homestead in this hypothetical, nor can it impose a lien upon the homestead. The credit card company is out of luck in this hypothetical to the tune of $7,000. That's the effect of this homestead law. Note some things in that hypothetical. First, you're the lawyer who's meeting with the grieving co-owner. Do they get the property free and clear of the mortgage? Can they stop making mortgage payments? No. The mortgage still has to be paid. A death won't eliminate the mortgage. Certain types of mortgage insurance might eliminate the mortgage upon death. Perhaps a life insurance policy can help fund the elimination of the mortgage upon death. But the homestead law is not going to eliminate the mortgage on the homestead. Take that knowledge to its extreme. What if I decide to buy a home here in Florida? I decide it's my homestead. And then as the mortgage bills come in every month, I laugh and throw them away. And then the mortgage company does what after it's blowing up my phone? Files a foreclosure action. I'll be pro se, a lawyer who represents himself as a fool for a client. So I'll go into the court with my ignorance of the homestead law. And I'll say, Your Honor, I'm not paying these bills. It's a homestead. And what will happen? I'll lose my house, right? Yeah. You don't get a free house from the mortgage company if the mortgage is the purchase money for the homestead. Likewise, what if you take out a second mortgage and you secure it with the homestead? Again, you don't get free mortgage money. You got to satisfy that too. Property taxes. Got to pay them. The roofer puts a new roof on the house. Got to pay him. The handyman who does the repairs and the handywoman who mows the lawn. Got to pay her or him. So the homestead is a protection from certain creditors, but not others. And it's easy to remember which ones you're not protected from. We're talking about taxes and liens for purchase and improvement of the property. Those creditors don't go away empty-handed. If they did, we'd have a little breakdown in society, would we not? How many banks would continue to make mortgages if nobody ever paid the mortgage, right? Wouldn't work. One of the protections of homestead is that in certain circumstances, it cannot be devised. In other words, if it is your homestead, in certain circumstances, you don't have the right to decide who gets it. What do I mean by that? What is meant by the Constitution of the state of Florida saying that the homestead cannot be devised? It means three different things. Here's the first thing that it means. The deceased can draft a will or any other type of estate plan. Might choose a will later with a codicil added. Might choose a will that's a pour-over will and has a revocable living trust. Maybe even an irrevocable trust. Whatever the estate plan might be. It does not void or avoid homestead protection when there is a surviving child or a surviving spouse of the deceased. The reason for that is when there's either a surviving child or a surviving spouse of the deceased, no type of estate plan controls the devise of the homestead. Indeed, if you've done any probate work here in the state of Florida, you know that you can file a petition to determine homestead. And upon proper proof, the probate court will recognize the home as being homestead, will award title to the proper heirs, and that asset leaves probate. Doesn't hang around to be sold or liened by creditors because it wasn't the will and its codicils. It wasn't the trust that decides who gets it. It was the homestead law that decides who gets it. Whenever there is a surviving child or a spouse of the deceased. That's the first of three things that Florida's Constitution means when it says that the homestead can't be devised. The second thing it means is that the surviving spouse is going to inherit the homestead. And that's true regardless of what the deceased wanted. It's true regardless of what the deceased put in the deceased's will. It's true regardless of the fact that the property was deeded to a revocable living trust and the trust says otherwise. Instead, the surviving spouse is going to inherit one of these two things, either A or B. The surviving spouse inherits either A, a choice of a life estate, or an undivided 1/2 interest if the deceased children survive the deceased. The spouse gets to make the election post-mortem, not the spouse's mortem, but the deceased's mortem. So after the deceased spouse passes, the widow or widower gets to choose whether they want a life estate or an undivided 1/2 interest in the homestead. What happens to the rest of the bundles and the sticks of the property ownership of the homestead? The surviving children hold the vested remainder, and they hold it per stirpes. This is true whenever there's a surviving spouse, and there's also one or more children of the deceased who have survived. What if there are no children of the deceased who have survived the deceased? That brings us to choice B on our slide. If that's true, that all the descendants, all the children of the deceased, predeceased the deceased, then the surviving spouse inherits the homestead in fee simple, with one exception and one exception only, if the spouse waived that right. You have a question?
I do, okay, so let's say husband and wife buy a house, and they enjoy tenancy.
Yeah.
And it's both equally the husband's homestead and wife's homestead, right? Because they own it jointly, but each person.
It can be, and by law, it must be
Right.
both their homesteads, because case law precedent says that a married couple can't own two homesteads.
Right.
It may be true that they're separated and they're not living together, but the law is only going to recognize one property as the homestead.
Perfect, so husband and wife live there, it's both their homestead. So if the husband dies and the wife only gets the life estate, why wouldn't it be just treated as her homestead, just as if they were, you said like if you co-tenants, they could still be your homestead, you know what I mean? Like, I don't understand why she wouldn't just get it and be simple. And then-
Yeah.
Because what if he has a child that's not her child? Like, he's the guy, the husband could have children with a previous wife, that's
Yep.
his lineal descendant.
Yep, that could happen.
And so his wife is only getting the life estate, but maybe she has a child that is not, families or.
Yeah. So if there's no lineal descendants that survive the decedent, then the spouse gets it in fee simple, unless you waive that right. But there could be a surviving child or descendant. If so, then the spouse makes the election, one or the other, either picks the undivided 1/2 interest or picks the life estate. Because we're reserving some ownership to the surviving children, they're going to get that vested remainder. It's a policy decision that was made, maybe we could track it back to 1968 when we last tore up and enacted a new constitution here in the state of Florida. But of course, prior constitutions contained remnants of this. For whatever reason, it's in Florida's constitution and it persists and exists today. Maybe it's not the right policy decision, but it's the policy decision that is on all fours of that document, and that's the policy decision that the courts will enforce.
So you hear like they say, oh, I disinherited, I have 4 children, but I disinherited my son or my daughter because for whatever reason.
But see, you can't. You can't. Yeah. To the extent that a Floridian wants to disinherit a spouse or child, a Floridian's hands are tied when it comes to the homestead. When it comes to other assets,
Right.
those other assets could be disinherited because the will and its codicils or the trust will control and decide who gets what. But regardless of what the will and its codicils or regardless of what the trust says, here's what happens to the homestead. You don't have the right as a Floridian to devise it in any other way because the courts aren't going to enforce. They're not going to enforce what's in the will, the codicils, or the trust. They're going to follow this homestead law of devising the property that is the homestead instead of what you put in the wills, the codicils, and the trusts. Did I answer your question?
You did.
Okay. And you had a question, sir.
I kind of do. So even if the husband and wife put the property into a trust before, so that it's not even in their name technically,
Right.
the deed is registered under the trust name,
Right.
the statutes in the Constitution still remove it from the trust control.
Correct.
Chapter 1 of them.
I was saying correct while you were talking, so I didn't hear the last part. But until I said correct, you were correct. But then after I said correct, you said more. Let me hear that part again, make sure that's correct.
So it removes control of the property from the trust
Mhm.
when only one of them dies.
Yes, correct.
Okay.
Correct.
So So you can have.
So that was all correct then. I was correct saying that was correct.
So then say that the surviving trust still wanted it to be held in a trust. Would they have to go through the process of redeeming it to the surviving spouse and then that spouse redeeming it into a new trust?
As a lawyer who sells such services, I highly recommend it. Yes. But this is two of the three. Did I answer your question?
Yes.
This is two of the three things that it means when Florida's Constitution says that the homestead cannot be devised. The third thing it means is a little bit simpler. Finally got a slide that's not full, huh? Despite the will and its codicils, despite the trust or the estate plan, the surviving children inherit if there's no surviving spouse, the homestead in fee simple. And how do they own it? They own it as tenants in common. Let's go back 2 slides and say it all as a mouthful. As a mouthful, what is meant when Florida's Constitution says that the Floridian can't devise the Floridian's homestead? It means 3 things. First, the estate plan doesn't void or avoid the homestead protection if there's a surviving child or spouse, because it doesn't control. The law instead controls. The spouse is going to inherit despite any will or trust to the contrary. Her choice of a life estate or undivided 1/2 interest if there's also a surviving descendant, a child or child of the deceased. Those surviving descendants are going to hold a vested remainder. They're going to own it per stirpes. But what if there are no such descendants of the deceased, even though there is a surviving spouse? If that's true, then the spouse inherits the homestead in fee simple. And that's always true with just one exception, if the surviving spouse waived that right. The third and last thing that it means when we say that Florida's Constitution doesn't allow the Floridian to devise the Floridian's homestead is that despite any will or trust or estate plan to the contrary, surviving descendants inherit if there's no surviving spouse, the homestead in fee simple, and they hold it as tenants in common. As wordy as that is, it is a simplification of a great body of case law. It saves you a lot of trouble of reading a lot of cases if you take the time to both memorize and understand how those 3 rules work. But what becomes of the homestead if the deceased is not survived by a spouse and is not survived by any descendants? No kids and no kids of kids. At that point, the heirs of the property lose the protection of homestead unless the deceased estate plan leaves the homestead solely to one or more of the deceased's family members who fall within the intestacy statute. Here in Florida, that's section 732.103 of the Florida statutes. Unless the estate plan leaves the homestead to someone who would have inherited it in intestacy, then that homestead is not protected from the estate's creditors. So the homestead protection would be lost. That sounds so awful until we consider the very broad definition of who inherits under Florida's intestacy statute, Florida statute 732.103. A brief outline of Florida's homestead law. Constitution of the state of Florida protects the Floridian's homestead in 3 distinct ways. First, a partial exemption from certain real estate taxes. Second, preventing a forced sale in favor of most creditors. Third, preventing the owner from bequeathing or devising the property to those who are not related to the owner in the case of a surviving descendant or spouse. I want to look a little bit more closely at that third one there, preventing the owner from bequeathing or devising the property to those who are not related to the owner. When we take a look at the case of Snyder versus Davis. Josh, thank you very much for helping me with the last case that came up here on the big board. Tanya, will you help me with this one? All right, ready for this one?
Yeah.
You're like the Snyder, you're like the Davis. It's a good case. Taught you a lot.
It was a little confusing.
Yeah, right, I'm with you. So I decided to boil it down using the IRAC method, IRAC. And Tanya, you walk with me, you make sure I got this right. Sound fair? Sound fair? Okay, IRAC issue, right? I. R, rule, right? A, Tanya, help me.
Would be analysis.
Analysis, there you go. C, conclusion. IRAC, IRAC. Okay, issue of Snyder versus Davis. Tell me how I did. Mom disinherits adult son and leaves homestead to granddaughter. Can PR sell homestead to pay estate's debts? Or, personal representative. Sorry. Under Florida's probate statute, we don't use the term executor or executrix. We've replaced that term with the term personal representative. This is the appointed individual that actually does the work. The judge, the probate judge, is there to enter orders and ratify and decide disputes, but ultimately doesn't do the work until called upon, unlike the PR, who's actually feet to the ground, pounding the pavement, doing the physical work. PR, personal representative. So issue. Tanya, how did I do? Did I summarize the issue of Snyder versus Davis well when I said mom disinherits adult son and leaves homestead to granddaughter? Can PR sell homestead to pay estate's debts, or instead is homestead protected from PR's forced sale? Like it? All right. I thought maybe this is the rule we get from Snyder versus Davis. Tell me how I did. Come on, man. I swear I didn't do that on purpose. Okay. An owner without a surviving spouse or minor child may bequeath the homestead to any heir, and the homestead protection survives. Heir includes anyone named in the intestacy statute. Tanya, how did I do? Keep in mind, I'm trying to get this right.
She died in custody. Didn't she?
I thought she disinherited her adult son and left the homestead to the granddaughter. No? Huh? Snyder versus Dave. Let me see. I want to get this right. Let's see. Yeah, let's see. Okay, facts.
She died
Betty Snyder died testate.
Yeah, sorry.
Yes. Those words, yeah, especially if you say them quickly, they sound very similar, but we know the vocabulary. Testate means you died and you had a valid will at the time of your death that we're now going to use to govern the probate proceedings. If you either never wrote a will or you wrote a will that was flawed and can't be recognized as a valid will, then you died intestate. Okay. Whew. All right. Thank you. Thank you for keeping the audit in place. But so far, I'm doing good, right? So far, I'm okay. So the issue is that mom disinherits adult son and leaves homestead to granddaughter. The PR, however, knows that the estate has debts. And the PR is thinking, well, okay, there's no homestead protection on this one. There's not a surviving spouse, right? There's not a surviving person that would qualify this for homestead, or so the PR is thinking, right? The rule of law is an owner without a surviving spouse or minor child may bequeath the homestead to any heir, and the homestead's protection survives. Heir includes anyone named in the intestacy statute. Agreed?
Absolutely.
All right, so far so good? Let's see if I can go further and still keep it right. Analysis. Both granddaughter and adult son are named in the intestacy statute. Mom picked granddaughter, and nothing required otherwise. Like it? So far so good?
Absolutely.
So the conclusion, therefore, granddaughter inherits the homestead, and she does so free and clear of the estate's creditors. And she avoids the forced sale by the personal representative. How'd I do?
Perfect.
Did I get it? Do you get it? Do we all get it? We all got to get it. You can get it? I was about to sing, but you know I shouldn't do that. Okay. All right. Homestead protection is lost unless the deceased estate plan devises the homestead solely to one or more of the deceased family members who fall within the class of persons named in Florida's intestacy statute. Okay? But that includes just about anybody related to the deceased. Here in Snyder versus Davis, the dispute was the adult son didn't get it. The granddaughter got it. But both an adult son and a granddaughter appear in Florida's intestacy statute, 732.103 Florida statutes. Don't believe me? Well, that statute is so rambling, I can barely fit it on a slide. 732.103. The part of the intestate estate not passing to the surviving spouse or the entire intestate estate, if there's no surviving spouse, descends as follows, according to this intestacy statute. 1, to the descendants of the decedent. 2, if there's no descendant, to the descendant's father and mother equally, or to the survivor of them. 3, if there's none of the foregoing, to the decedent's brothers and sisters, and the descendants of the deceased brothers and sisters. 4, if there's none of the foregoing, the estate shall be divided, one half of which shall go to the descendant's paternal, and the other half to the decedent's maternal kindred in the following order: A, to the grandmother and grandfather equally, or to the survivor of them. If there's no grandfather or grandmother, then to uncles and aunts and the descendants of them. If there's either no paternal kindred or no maternal kindred, to the other kindred who survive in the order stated above. If there is no kindred of either part, the whole of the property shall go to the kindred of the last deceased spouse of the decedent. If the deceased spouse had survived the decedent and then died intestate, as if that were true. If none of the foregoing, and if any of the descendants of the decedent's great-grandparents were Holocaust victims, then to the descendants of the great-grandparents. I mean, who have we left out here? The state. We've left out the state of Florida. It didn't escheat, did it? E-S-C-H-E-A-T, meaning an asset claimed by none, which then falls into ownership by the state of Florida. It didn't escheat. Yeah. Notes and questions to consider for Snyder versus Davis. Page 343 at the bottom is number 3. As seen above, Snyder versus Davis holds that homestead protection is lost after the death of the homesteader unless his or her estate plan devises the homestead solely to one or more of his or her family members who fall within the class of persons categorized in Florida's intestacy statute, section 732.103, which was that rambling monstrosity of a law that I just had on, what was that, 7, 8, 9 different slides. And that wasn't even verbatim, that was a summary of it. Yet the intestacy statute lists a long and deep line of consanguinity. Did I pronounce that right? Consanguinity? C-O-N-S-A-N-G-U-I-N-I-T-Y. Consanguinity. Thank you. I can write it. I just can't say it. Snyder versus Davis cites the State Department of Health and Rehabilitation Services versus Trammell. This is a 1987 decision of Florida's First District Court of Appeal for the example that, quote, a devise of homestead to a good friend does not qualify for the homestead exemption, end quote. In light of the depth and breadth of Florida's intestacy statute, are there any other examples? Not much, right? What if I leave it to my favorite charity? That would be an example. That would be an example. What if I left it to my church or my synagogue or my mosque or my religious order? That would be an example, right? So there are some examples. They're few and far between. If under facts like these in Snyder versus Davis, you don't have a surviving spouse, but you do leave the property and you don't have a surviving spouse and you don't have a minor child, but you do leave the property to somebody, anybody, who shows up on the intestacy statute, then they're going to inherit that homestead free and clear of most creditor liens, right? The PR, personal representative, is not going to be able to sell the homestead to pay the unpaid debts of the estate. So we're talking about granddaughters and grandsons, nieces and nephews, grandparents, great-grandparents, cousins, right? You saw them on the list there. These people might be far removed from the deceased, but so long as they're on the intestacy list, and you saw its depth, you saw its breadth, you saw its length, you saw how inclusive it was, then that homestead is going to avoid the forced sale of creditors of the estate. So you see how powerful an asset protection law this is. Say you're blessed to have some money that you don't want to part with. If you take that money and buy yourself a homestead, true, the money might be tied up in the homestead, but it's not going to the creditors of you that you can control. You can choose certain creditors to have a certain status who will have access to your home equity as a Floridian. Why do I put it that way? Well, when it comes to property taxes, maybe that's an unfair way to put it. It's not really possible to avoid property taxes. You can lower them a little bit by declaring it as your homestead, and then you get that $25,000 exemption. The first $25,000 in real estate value is not subject to the ad valorem taxation of the property tax. But other than that, you're stuck with the property taxes. If you use the mortgage for purchase money, then you're stuck with the mortgage. If you maintain the house and you don't put in the sweat equity, you instead hire the contractor or the roofer or the handywoman or the handyman or the repair folks, then you're subjecting yourself willingly to a debt that can't be protected by homestead. But that's it. That's the list. That's the exceptions. All other debts on your honor, you should be paying. But the homestead will protect the home from forced sale, execution, or even a lien placed by those creditors. That's going to be true while you're alive. And if you draft your estate plan properly, it's going to be true after you're dead. Ironically, if you were irresponsible enough to not have an estate plan, then what would apply? The intestacy statute. And as Snyder v. Davis teaches us, if your homestead is inherited by anyone on the intestacy statute, then that's going to protect the homestead from creditors. So for this quote unquote irresponsible who died intestate, died without a valid will, the intestacy statute does the work for them of protecting the homestead from most creditors. So you see the power of it. We're fading fast. I took that break early. Maybe we're paying the price for that. How about a 5-minute break? Sound good? 2 breaks in 1 class? McGinley, you're getting soft. I'll see you in 5 minutes. I got you. Well, there's lots of things we don't stick with. Oh, that's not. Say I go to the bank and have a payable on that on bank. The number of the state plan says bank. Say that life insurance policy beneficiaries doesn't have a state plan says. Right. So the bill is not like to be on all those things anyway. So that part's not.
Right, no, I understand.
Yeah.
That the Constitution and statute, have kind of open rules, anything that.
Right, right. But that's not unusual. That's not
So my question is, hey, where do you see in the last case, how did that come in? It shouldn't just be
unless she's so basic. There was no survivor spouse, there were no children. So the PR thought, well, somebody's supposed to be protecting the spouse and my children ain't happy, so I'm selling it.
Right,
And she had a fault, so she disinherited. Right, so she wasn't giving it to the kids anyway. I did the homestead. She trumped. So there's a big issue.
how did the homestead disinherit? Because So those rules were. Then you see the homestead controls, you get. And that's a better, and then the. That person gets property. So there's no
Homestead was the martial arts. Now, they must give it to their friend or charity.
Okay, so if anyone is alive, they still and then finally, when the children share tenants, they themselves use any protection in homestead. It's still protected from homestead debts. Because they don't get homestead protection unless they live there prior to like they can't inherit a second. Because if there's no capital.
But the homestead law is creditors
Right, the original homestead. Right. So if I get
now you're talking about
right. So if I inherit my parents, I no longer homestead protection, so my creditors can go after them. Because unless I move there, live there, I don't get homestead protection on my property.
you want to come up here and stand? Come on.
You don't get paid for that. That's your job.
Darn it. All right. A short break, but a timely one, because I had a great conversation during it. I tried to con you into coming up here and explaining all that to everybody. Let's see if I can do it, huh? Now, Snyder versus Davis is pointing out an important rule of law, is it not? And I've got it here on my IRAC slide. See here, we've got how mom is disinheriting an adult son and leaving the homestead to a granddaughter. So it's pointed out to me that, I kept bragging how I can read, but maybe I wasn't reading very well. Note how Snyder versus Davis is talking about an adult son, So there's a difference here when we're applying the homestead, because what we're talking about is either a spouse or a child. Remember my slides over here talked about a child, which I was misreading to be equivalent to a descendant. What I'm talking about in this set of slides here is not a descendant. That's a misreading of my own slides by me. What I'm talking about here is a minor. I'm talking about a child. So let me go over these 3 slides again to avoid any confusion that I myself may have caused you. And to the extent that I caused any confusion, please know that I apologize for that. You know, in education, they talk about a concept called degree of original learning. What this concept boils down to is if you learn it wrong the first time, it's harder to unlearn it. So I hope no one learned it wrong the first time. I hope I haven't put you in the predicament of having to unlearn anything. Let me go through my own slides again and read them more carefully, because the slides were correct. But as I embellished upon them and read them out loud, I may have given you the wrong impression that we're talking about in these 3 slides an adult child. We're not. We're talking about a minor. So let's look at these slides again about what is meant by the Florida Constitution saying that a homestead cannot be devised. It means 3 things. First, the will, revocable living trust, whatever the estate plan might be, does not control, does not void or avoid homestead protection if there is a surviving child or spouse of the deceased, because it does not control the devise of such a homestead when there are such survivors. And for more details, the statutory site there is Florida Statute 732.4015. That's the first of 3 things that it means when we say that Florida's Constitution prevents a Floridian homesteader from devising the homestead. The second thing it means is that the surviving spouse is going to inherit despite any will or trust. 1 or 2 things, A or B. Surviving spouse might inherit A, the spouse's choice of a life estate or undivided 1/2 interest. That's if the deceased's kids, and I use the phrase kids literally there, survive the deceased. If so, then the kids, per stirpes, hold a vested remainder. The other option is that perhaps that the kids did not survive the deceased. If that's true, then the spouse inherits the homestead in fee simple, unless the spouse waived that right. This A and B choice, this A and B option, summarizes the second of 3 things that it means when it says that Florida's Constitution prevents the homesteader from devising the homestead. The third thing it means is that despite any will or trust or estate plan, the surviving kids, take that literally, kids inherit, if there's no surviving spouse, the homestead in fee simple as tenants in common. The statutory citation there for more detail is Florida Statute Section 732.103, specifically subsection 1. Okay, so Snyder versus Davis illustrated that point. And it illustrated it when it said how mom was disinheriting an adult son and leaving the homestead to the granddaughter. The rule of law was that an owner without a surviving spouse or minor child, or to use the slang term I had in the prior slides, kid. There I wasn't referring to a goat, I was referring to a minor child. An owner without a surviving spouse or minor child may bequeath the homestead to any heir, and homestead's protection survives. Heir includes anyone named in the intestacy statute. So the analysis of this case, both granddaughter and adult son are named in the intestacy statute. Mom picked the granddaughter, and nothing requires otherwise. If my prior explanation of those 3 slides implied that something required otherwise, I gave you the wrong impression. Nothing requires otherwise. If there's a surviving spouse, that could require otherwise. If there are surviving minor children, aka kids, that could require otherwise. But if we've got a granddaughter, we've got an adult son, then the deceased could pick one. and leave to that one and only one the homestead, because nothing required otherwise. So what was the outcome of Snyder versus Davis, according to the Supreme Court of Florida? The outcome is that the granddaughter inherits the homestead, free and clear of creditors of the estate, and avoids the forced sale by the personal representative of the estate. What was the personal representative of the estate wanting to sell the homestead for? To pay the creditors of the estate. But the personal representative was not allowed to do so because that homestead was protected by the creditor protection laws of Florida's homestead laws. Florida's homestead is going to protect that property from the heirs, and the credit is going to protect it for the heirs, and is going to protect it from the creditors of the estate. But the question was raised during the break, and it was an insightful one. What if the beneficiary has creditors, and the beneficiary already has a homestead? So in the hypothetical question posed to me during the break, there was a beneficiary who already had a homestead. That beneficiary became the heir of the deceased real property. That real property is not the beneficiary's homestead. It was the homestead of the deceased. Under such a hypothetical, it is the creditors of the estate of the deceased who can't touch the deceased's homestead, but the creditors of the beneficiary can touch what used to be the deceased's homestead, because it's not the beneficiary's homestead. The beneficiary has a different homestead. So the beneficiary's creditors probably won't be able to touch the beneficiary's homestead, but now in addition to that real property, the beneficiary is about to inherit some more property, which is not the beneficiary's homestead. The beneficiary's creditors may be able to get at that asset. So that was an insightful question. I appreciate that. It was off the facts of Snyder versus Davis, but I think it was important to point out. So I was thankful for the question. And I'm always thankful for your questions. Doesn't have to be a soliloquy up here. Interrupt me anytime you like. Who knows? I might even talk to you. Just kidding. Just kidding. I would certainly talk to you. Certainly talk to you. All right. So we know that homestead protection is lost unless the deceased estate plan devises the homestead solely to one or more of the deceased family members who fall within the class of persons named in Florida's intestacy statute in those instances where there's neither a surviving spouse nor a minor child surviving. And that's why we looked at the intestacy statute and saw just how many people were included in it. And my gosh, it was almost anyone you could think of. But let's dive a little deeper, shall we, into that property is a bundle of sticks concept that you heard over and over again when you took property law in your 1L semester. Homestead exemption for forced sale. When may it inure to co-owners? And I draw your attention to Joe Procopo's awesome Florida Bar Journal article that he wrote in May 2012, and he was kind enough to allow me to reprint in my books. You know, even someone as vain as myself can on the rarest of occasions admit that he couldn't have said it better. I couldn't have said it better than Joe did. So I'm thankful that Joe was kind enough to allow me to reprint it in so many of my books that I write. I just copy and paste what Joe wrote because it couldn't be improved upon. And this is one such example. We're talking about here impact of co-ownership and creditor protection. Join me at the bottom of page 344 and quickly moving to the top of page 345. This article is examining how co-ownership of property affects the homestead creditor protection. So what degree of protection do you get under homestead if you're a co-owner? The first question is one of tenants by the entirety. And as you know, only married couples can own property as tenants by the entirety, right? So what we're talking about here are spouses, lawfully wedded spouses. Now there's a presumption here in Florida that if two lawfully wedded spouses acquire property during the marriage, it is presumed to be owned as tenants by the entirety. Does it help to label it as such? Well, of course. But the burden goes on the creditor to prove that it's not owned as tenants by the entirety if it was acquired during a valid and legally recognized marriage here in Florida. So for the most part, if you and your spouse acquire something during the marriage, you're going to be owning it as tenants by the entirety unless you do something to label it otherwise. Now, if either spouse qualifies for the homestead creditor exemption, then the property is afforded protection from both spouses' creditors. With that said, when BJ and I were talking earlier, I pointed out that under the case law, lawfully wedded spouses can't establish two separate homesteads. It's been tried. It's nice to have the beach condo as well as your main home. And it would be cool if maybe we'll put the husband on the beach condo and the wife on the main home and call them both homestead. But no. It's been tried. It's been rejected. The case law says no. Even if the spouses are separated and working on a divorce, maybe they've even got one filed at the courthouse. Still, until the divorce is final and the dissolution of marriage order is signed and final, they can't have two separate homesteads. So it would be unusual indeed that one spouse qualifies and the other doesn't. But in such a case, when it's a lawfully wedded spouse situation, the fact that one spouse qualifies gives the homestead full creditor protection for both spouses. Unless the divorce decree makes one spouse a complete owner, the spouses become tenants in common after the entry of the divorce decree. So most divorce decrees are going to decide who owns the property, right? But in that odd situation where maybe the divorce decree is silent, or maybe the dissolution of marriage order is signed and there's still other issues to be decided during that interim period, they're considered tenants in common. And that's important because now let's look at tenants in common. Unless specific language is used including or indicating survivorship rights, tenants in common is the default form of co-owned property in Florida. So if you simply file the deed saying it's owned by X and Y, and you say no more, what does the law interpret? Does the law interpret them as joint tenants with rights of survivorship, or does the law interpret them as tenants in common? Here in Florida, the law interprets them as tenants in common. What's the difference between tenants in common and joint tenants with rights of survivorship? The answer is in the question. The joint tenants with rights of survivorship have rights of survivorship, yes, whereas the tenants in common do not. So to bring you back to your property law class, looking first at tenants in common, the property is owned by X and Y, period, says the deed. The law says X and Y are tenants in common. When X dies, who owns the property? Why? I'm not asking the question why. I'm saying of X and Y. The answer is Y, the letter Y. Yes, let's call it A and B. A and B are tenants in common. A has died. Who owns the property? B. Yes. But what about the heirs of A? A wrote a will. Said, I leave my half of the property to my spouse or my children. Sorry. That property wasn't yours to bequest. It wasn't yours to bequeath. It wasn't yours to put in a will and leave to another. You were a tenant in common. You had no rights of survivorship. Another alternative is that you might create a joint tenancy with right of survivorship. Since that's not the default, you have to do that on purpose. You have to draft yourself into that ownership status. A deed in Florida that merely says this property is owned by A and B, period, is not a deed that creates joint tenancy with right of survivorship. Now, here's the relevance of these two different types of ownership when it comes to Florida homestead. Co-ownership of property, in other words, tenants in common, will not prevent an owner from claiming the homestead creditor exemption. However, the status of each co-owner impacts the level of creditor protection retained by the property. Follow with me now. I'm in the middle of page 345. When all co-owners qualify for the homestead creditor exemption, the home will be exempt from forced sale and liens. Okay? So unlike the tenants by entirety, where one spouse's qualifying meant you were protected by or from the forced sale and liens of either spouse's creditor, it's not the same when we talk about tenants in common. Tenants in common, I need all the various tenants in common to qualify in order to fully protect the property from any of the tenants in common's creditors. When at least one co-owner does not qualify for the homestead creditor exemption, a potential problem exists, says Joe Percopo. Spoiler alert, what's that problem going to be? That creditor might impose a lien or even a forced sale, right? Let's look at how that might happen. If a co-owner does not qualify for the homestead creditor exemption, a creditor of that co-owner can acquire that interest and then force a sale. See that? A creditor of that co-owner can acquire that interest and then force a sale. But it's my homestead, says the other co-owner. Not anymore, says the creditor. But I'll be homeless, says the other co-owner. Yes, but you'll at least get a check for your interest in the property, says the creditor. Minus the expense of sale, says the creditor. And minus the attorney fees, says all the lawyers. I like Joe's quote here. This is true because, quote, this is from Joe. Thank you, Joe Percopo. A chain is only as strong as its weakest link. Yeah. And you, co-owner, who doesn't qualify for the doesn't qualify for the homestead law, you, co-owner, are the weakest link. Goodbye. Am I the only one that knows that game show? Yeah. That's a cool show, right? Yeah. Is it still on the air? I don't think so. It just ended? Oh, well, they got to bring it back some more. Yeah. Thanks for weakest link fans. Appreciate that. All right. All right. Over here. Property will be completely shielded from creditors when all co-owners qualify for the homestead creditor exemption. However, if at least one co-owner does not qualify, the property becomes subject to that co-owner's creditors. This is extremely important to understand when acquiring property with others. And here's where Joe gets really practical, which is what I like to do. I like to get really practical with this information. You're my fellow lawyer. You probably want to be practical too. Joe says, quote, it is common to see family, especially parents and children, purchase property together or add each other to the title of property. And you've seen these kind of self-help solutions to estate plans, right? Or sometimes they're even done side by side with the estate plan, right? Who hasn't seen the grandparent who put the granddaughter or the grandson or the niece or nephew literally on the bank account, That way when they pass away, they can get the money, But these things have consequences when it comes to real property and it comes to Florida's homestead law. Joe continues, quote, parents need to know that if they place a child's name on the deed and that property is not the child's homestead for creditor protection purposes, then that property is subject to the child's creditors, right? So if grandma or grandpa or whoever it is adds a loved one to the chain of title in a certain way so that they qualify as co-owners, or stated somewhat differently, they qualify as tenants in common, which, as we know, is what they qualify as unless you draft it otherwise, then grandma or grandpa or whoever drafted that deed has done more than just adding them to the title. They've added their creditors to the list of folks who can force a sale of that property. right? So that's important to know. Joe goes on, quote, additionally, children need to be aware that if their parents are on the title to their homestead, open paren, maybe they helped purchase the property many years ago, close paren, that property is subject to the parents' creditors. Another good point, right? You got some kids, you're going to buy them a house or help them buy a house, maybe help finance the house, but maybe there's still a mortgage. Maybe you want to know if the kids fall behind. You don't want them to get evicted upon. So you put yourself on the title. The kids have to understand that you're putting your creditors in line for a forced sale for that house, right? So Joe raises some good points there at the top of page 346. He goes on to another section in the middle of page 346. He's talking about life estates and remainder interests. That's when we talk about dividing the interest of property into present and future estates, okay? Remember, one of the choices in the slide, and let me get it back on the big screen so you remember which one I'm talking about. One of the choices the spouse had, when we looked at this set of 3 slides, and we looked at it twice, you're probably getting bored at it by now, we're talking about what it means when Florida's Constitution says that the homestead cannot be devised. And the second of the 2 things we talked about is that a surviving spouse is going to inherit no matter what the deceased might try to do to disinherit a surviving spouse. Short of an order dissolving the marriage in a divorce or dissolution of marriage proceedings, nothing's going to disinherit a surviving spouse. One of the choices a surviving spouse might have if the surviving spouse doesn't inherit the homestead in fee simple because he or she is the surviving spouse and there are no minor children. If there's minor children that are the descendants of the deceased, then the surviving spouse is making a choice. Remember, that was paragraph A on this slide. The surviving spouse is going to choose either a life estate or an undivided 1/2 interest. What's that first thing there, life estate? How's that different from the undivided 1/2 interest? Well, it's one of present possessory right. The difference there is a difference of present possessory right. If I own a life estate, that means I own it until I die. After I die, and as soon as I die, it immediately vests in someone else. The legal term for that someone else is remainderment. Perhaps it should be remainder person. Perhaps someday it will be remainder person. But I've always seen it expressed as remainderment. So these remainder people automatically vest ownership upon the death of the person who holds the life estate. But more relevant is that the remaindermen do not have a present possessory interest. They can't live there. Can the life estate person invite them over for dinner? Well, yeah. But the remainderman can't say, hey, you life estater, get out, I'm moving in. They don't have any present possessory interest. So Joe Percobo is talking about these types of life estates and remainder interests in this second part of page 346. And you see how this is one instance of a way that such a possession can arise. What's another way that these can arise? Ever heard of a ladybird deed or an enhanced life estate deed? They're popular here in Florida because under Florida property law, unlike the property law of many other states, the ladybird or enhanced life estate deed is recognized in such a way that if you draft it properly, the folks who used to be the fee simple owners and transformed themselves into life estate owners can undo that designation of theirs and once again become fee simple owners, even over the objection of the remaindermen. In most states, the remaindermen have enforceable rights that make a ladybird deed or an enhanced life estate deed impossible under that state's law. Under Florida law, it is possible if drafted properly. So that's another example of how a life estate can arise. So you might see these in your practice. Joe tells us, Mr. Percopo says it best, so I'll read it out loud. Quote, to determine if and how the homestead creditor exemption applies to life estates and remainder interests, he notes that remainder interests, including vested remainders, were not able to qualify for the homestead creditor exemption, even if he or she lived on the property, because there was no present right to possession. Thus, a life tenant can qualify for the homestead creditor exemption with a life estate. So yes, a life tenant can qualify for the homestead creditor exemption if their only interest is that of a life estate. However, the Florida Supreme Court has determined that a remainderman cannot qualify with only a remainder interest. End quote. McGinley, what is Percopo saying? Well, think about this. You draft for your client here in Florida an enhanced life estate deed, which is its technically correct name, but its slang term, if you will, is ladybird deed. In other words, you've put a beneficiary on the deed, just like your client might go to the bank and fill out the correct forms, and the bank account is payable upon death to someone, just like your client might go to the stock brokerage and under the terms of the brokerage contract in federal law might fill out that brokerage's proper forms and create a death beneficiary. Here in Florida, you can do a very similar thing by drafting an enhanced life estate deed where the former fee simple owner now leaves to herself or himself or themselves only a life estate and creates one or more remainder persons who in turn might have fractional interests. If that's part of the estate plan, is the real property still homestead? Yes. If that's part of the estate plan, does that real property still have homestead protection from creditors? Yes. That's what we're saying. What if I move in with mom and dad, both of whom passed, may they rest in peace, but I move in with mom and dad, and they've created one of these ladybird deeds, enhanced life estate deeds, and I'm the remainderman. Do I have enough ownership interest in this property to claim homestead? Joe Percopo is telling us no. He's saying, quote, the Florida Supreme Court has determined that a remainderman cannot qualify with only a remainder interest, end quote. So the answer is no. To finish these quotes from Joe and to finish our class, Joe Percopo says, quote, when the life tenant qualifies for the homestead creditor exemption, the property is still protected from the life tenant's creditors, but it is not safe from the remainderman's creditors, co-owners who share interest in time. Unlike co-owners who share present interests, may not partition life estates. Therefore, a life tenant could continue to reside on the property without worrying about the remainderman's creditors being able to force a sale of the property. It is late in the evening and we are diving deep into Florida real estate law, are we not? So even though class is supposed to end exactly 1 minute from now, please accept my heartfelt apologies when I shave 1 minute off of your instruction time, because this is the perfect place to end, because it leaves us with the following cliffhangers. First, that thing I just read, what did it mean? Second, what about the impact of co-ownership in other situations that Joe Percopo talks about on pages 348 through 351? And third, what about the lawyer who secures homestead money benefits? Can the lawyer take his usual 33 or 40%? We will answer all these questions and more when we return next week and spend 2 more beautiful, fun hours on Florida Homestead. Until that time, may God continue to bless us all. Thanks for putting up with me. The semester's almost over, so you almost got me out of your life. Hang in there. I'm going to get you to a great practice of law, pass the Florida bar exam, and give you a wonderful profession to live under. Until then, I'll see you next week. God bless you.